Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. There is apparently a first in this case where one of the parties have filed not one, but two responses to the same request for discovery. Discovery being evidence whichever party, whether it's the defense or the state, believes is in the custody or control of the other side pertinent to their case. The discovery request in question here is the defense's 23rd supplemental request for discovery. As we reported in a prior episode of the Indie Zone, as has been the case since the beginning of this proceeding, when Mr. Kohberger served discovery, what he was asking for is in an exhibit. This is Exhibit S1. We are up to the letter S because this is now the 23rd following 22 prior supplemental, meaning additional requests for discovery. The exhibits have all been filed under seal since the beginning of the case, and the 23rd supplemental was no different. Well, we then see the state of Idaho coming forward, filing their response. They have attached their own Exhibit S as in Sam 1 in kind, responding to the defense's S1 exhibit. In their filing of 4:13 p.m. of June 3rd, the state has filed a motion to seal that exhibit, S as in Sam 1, regarding the state's response to defendant's 23rd supplemental request for discovery. They cite to Idaho Code Administrative Rule 32 G1 and Idaho Code Section 74124B. The first is a rule of court, the other is a statute in Idaho that allows a court to seal certain documents from public disclosure for certain reasons. And the reason given here, where the state is asking that their Exhibit S as in Sam 1 attached to the state's response to defendant's 23rd supplemental request for discovery should be granted because of a previous stipulation. That means an agreement of the parties to seal exhibits which contain facts which have not been made public. So whatever it is in this exhibit is information that has not been made public on the docket. As a second grounds, the state is saying here would likely impede the ability of the court to find a fair and impartial jury if this information were made public. This is signed Ashley S. Jennings as Senior Deputy Prosecutor. And as I've mentioned, this was filed at 4:13 p.m. on the 3rd of June. Now, mere hours later, effectively, the state comes back with a second filing. This was submitted June 4th at 8:33 a.m. This is their motion to seal Exhibit S1 to state's supplemental response to defendant's request for discovery. So what apparently happened here is, and we're giving an opinion because everything's under seal, is maybe the state found an additional document or additional information that perhaps was inadvertently not included with the prior exhibit that was filed the afternoon of the 3rd, and the state is asking here, citing to the same rule of court, the same statute, for an order sealing Exhibit S as in Sam 1 attached to state's supplemental, that means additional, response to defendant's request for discovery, giving the same reasons supported by a previous stipulation of the parties to seal exhibits which contain facts which have not been made public and would likely impede the ability of the court to find a fair and impartial jury. This is also submitted by Ashley S. Jennings on behalf of the state. If you would like to review these three documents of June 3rd and 4th, please go to the docket Idaho versus Kohberger and you can read them in total for yourself. This is Kathy. Thank you for joining us today.